So next we'll talk about the source of most disputes and how to address them. So piggybacking on what we just talked about, contracts are usually the main source of disputes, and there are verbal contracts, and there are actually contracts, as we just saw in the last example, that cannot be verbal. So you can have a verbal agreement, but there's a certain segment of contracts that must be in writing. A good example was the last slide where we talked about work for hire agreements to transfer ownership of property rights and how that must be in writing. And then there are written agreements. So there are written agreements that are well written, and then there are written agreements that are not so well written. The source of most disputes lies in either having a verbal agreement that the parties don't fully understand, or a written agreement that's not so well written. Let's look at an example of how we could potentially reduce the likelihood of disputes. So you hire a contractor, except this time you want them to create a website and a logo, and you say, all right, I'm going to put everything in writing. So you write it all down, and you say, the person will create a website and a logo for $4,000. It will take 2 weeks. Payment will be due upon receipt. So the contractor gets 2 weeks in, they give you a call. They say, the work is taking much longer than I anticipated. I'm sorry, I didn't think it would be this much time. I need an additional 2 weeks. Is that okay? You say, fine, I understand. Sometimes things take longer than you anticipate. I'll give you a 2-week extension. 2 weeks go by. You receive the file via email. Everything looks great. But then you receive an invoice for $6,000. And you might be thinking, well, how could that be? The person was late. They didn't deliver on time. How would I have to pay more? Well, the contractor said it's going to take more work. So that contractor may have interpreted that as meaning it will cost more, and I'm going to charge you more. Your impression was, well, it should have been done within 2 weeks, and it wasn't. I should really be getting a discount, not paying more. So the issue here is the contract. It doesn't speak to changes. It doesn't say whether or not changes have to be in writing or do not have to be in writing. What it is lacking is a merger clause. And certainly, if you're not an attorney, you wouldn't know that it's lacking this provision. So having this type of provision in your contract means that it merges all prior negotiations together, and it likely has a provision that says there are no oral modifications or verbal modifications to this agreement. And if you had this in your contract, what it would do is it would only allow changes to be in writing. And if those changes are not in writing, well, then they are not enforceable. Of course, there are always exceptions, but the point is that because we have a not so well written agreement, it resulted in the dispute, which ultimately a court will have to work out, and it will likely cost each side a lot of money.